Hello, ladies and gentlemen, welcome to Coin Lady channel. It's possible that the judge will dismiss the class action complaint against Ripple. The public was invited to attend a hearing as observers only, as reported just yesterday. It was impossible for them to communicate. Even though only 500 people could take part, I'm sure some of you listening right now took advantage of the opportunity. And participation through Zoom was mandatory. But now that some time has elapsed and lawyers have had a chance to consider the situation, they're speaking out and writing articles about it. What has been said since then is interesting, and I'd want to share some of it with you. The lawsuit pitting Zakinov against Ripple is currently before a judge. Since it is unclear which cryptocurrencies could be securities, the judge has stated here and again just the other day that the Ninth Circuit Court has not clarified whether courts can certify classes of investors, meaning validate them, so you can move forward with the lawsuit relating to cryptocurrency. This is a novel and unexplored area of the law. That's pretty funny, right? Which I'm sure you'll all find hard to believe. Everything is crystal clear now, since Kim Jong-Gensler said so. Right. This is crystal clear. The lawsuit could be dismissed for this reason. In addition, I have feedback on this issue from attorneys John Deaton and Jeremy Hogan. However, it is important to note that I come from neither a legal nor a financial background. You shouldn't buy or sell anything based on what I say or write because I am not a legal or financial advisor. I'm merely a hobbyist that occasionally posts films to YouTube about crypto-related subjects. And for lark's sake, in case you haven't been keeping up with the latest developments, I'll mention that this complaint was filed about 5 years ago. 6 months of 2018, so roughly 50 years ago. Because nothing here appears to make any sense at first inspection, reasonable curiosity and conjecture are warranted. But the real question is, why are they suing Ripple in the first place? Because the main plaintiff had only held XRP for a short period of time in 2018, a few weeks at most, and lost only a few $100s. It amounted to roughly that. I'm going off recollection here, but suffice it to say that whatever the precise details are, they pertain to a tiny amount of time. How can you believe that Ripple's efforts would have caused your supposed investment to gain in value if you held it for 2 weeks? That makes zero effing sense. The next step was to sue Ripple. So, why the heck are you hanging out in that place, you dummy? Stick. For 50 years, as you well know. And what do you earn if you win the class action lawsuit? The verdict could affect the situation by hundreds of dollars. In any case, it wouldn't amount to much. Moreover, you've been at this for 5 whole years. You know what I'm talking about when I say that. The following was written by a member of the community who prefers to be known only as the crypto meme guy. What matters is how much money Vlad Zakinov is getting paid to sue Ripple, not how much money he lost trading XRP. Don't waste a few years and $250 on a legal case. SEC is all over this. J.P. Morgan, and it's reasonable to assume that. I just can't put my finger on what's driving this. I won't conjecture that he's getting paid, but it's not out of the question. There's no way for me to know. I can only say that it doesn't make any sense to me. The vast majority of you who are listening are probably nodding your heads and wondering aloud, what the hell is going on here? Well, I guess we finally get to the bottom of this, though it's still largely conjecture. However, bear with me. Mr. Intuitive, a member of the XRP community, retweeted this and asked, who's funding his lawsuit? Because no attorney is doing it on a contingency fee to get a percentage of $500. A third of $500 is not enough to convince me, Jeremy Hogan. The point is, though, and it's true, nobody would do it for $500 if the plaintiff's attorney gets what he wants, which is much more money. So, here is what Jeremy Hogan, an attorney, had to say about it. The strategy here, I believe, is to sit back and let the SEC investigate the Section 5 violation. If it works, aim to get 10,000 people to join a class action lawsuit. A charge of $500,000. And for the XRP plaintiffs, there's a Thanksgiving turkey voucher. That's fantastic, you've got to adore it. A gift card to Starbucks has been enclosed. Instead, it's more along the lines of, but, that holds some truth. You can expect peanuts as a reward. You'll be included in the class I was just describing if the court gives his or her stamp of approval, which the judge must do before any of this can proceed. Not much of value will be provided to you here. But the lawyer would make out like a bandit if the fee was based on a much larger sum, say several $1,000,000. To be honest, I have no clue as to why the Zakinov character has stuck around for the past 5 years. But at least from the lawyer's perspective, that makes a little more sense, doesn't it, when you consider that this attorney may stand to make 7 figures. Okay. No need to show up every day if it's something you can leave running in the background. It's been 5 years since then. However, why the hell should you care? There's also this. In a moment, I'll get into the specifics of what happened during yesterday's hearing. However, John Deaton's temper flared up during the hearing, prompting him to tweet the following. "I've never been more irritated in all my years as an attorney as I am right now with this Zoom hearing," he added. Then, a person who only identified themselves as Big Wayne via email asked, "Why? Please expand on that." And so did Deaton, an attorney. The main reason, he explained, was that he was unable to answer the judge's questions or deal with the difficulties he had raised. There is a lack of understanding of the technology. Now, that's a serious issue, you guys. So you're debating whether or not to give a class official status? Meanwhile, the judge is attempting to learn about the technology but is still clueless about it, and he or she will have to make a significant legal ruling while remaining in the dark. That is a crucial consideration. And as I go through a bit of the piece from the Crypto Basic on this, you'll find that the judge is mentioning in the past how, there's some kind of supplementary crypto. I have forgotten the specifics. I don't think it was a hearing, but rather some sort of function. But the judge indicated throughout the entire case that anyone who was there, whatever it was, I'll have to go back and look it up, should consider themselves to be a witness. She reread the piece and said, "You ended up just as confused as we did at the start. So keep that in mind. I'm not trying to tear down the judge or anything, this just seems like a statement of reality that the judge still doesn't get. And she'll be making the final decision. It's never a perfect situation. But here's what I'll tell you anyway. I have no idea what will happen in the SEC v. Ripple case, but knowing that Judge Torres has made a concerted effort to learn as much as possible about the case, including the technical details that have no doubt been presented to her, fills me with gratitude. I will say this much, the amicus briefs were really helpful. And then there's something from the very beginnings of cryptography. Check out this headline about a federal judge in California weighing in on the security status of XRP in a class action lawsuit. The judge is debating whether to certify a class in Zakinov v. Ripple since the case presents a novel legal issue. According to Law 360, a subscription-based law news service, U.S. District Judge Phyllis Hamilton is weighing whether to certify the classes of selected investors who accuse Ripple of engaging in unregistered securities offerings following yesterday's class certification hearing in the Zakinov Ripple lawsuit. Judge Hamilton stated that the issue presents a question of first impression as to whether XRP qualifies as a registered security. According to Judge Hamilton, this is the most important part in determining whether or not this case will proceed, and the Ninth Circuit has yet to provide any clarification on the matter. Whether or not the courts can certify classes of investors who disagree on whether or not certain cryptocurrencies constitute unregistered securities is an open question in the Ninth Circuit. Let me pause for a moment. Several points. First of all, this does not necessarily rule out the possibility of certification for this group. It's not a definite guarantee that it'll end up in the trash. It's entirely possible that the judge will dismiss the complaint, but that possibility raises serious doubts about the likelihood of the former. I don't know if you're familiar with the phrase loggerheads, but I certainly wasn't until recently. So, I looked it up on Google before writing down the current temperature in the room. It's convenient to carry the sum of human knowledge in the form of a smartphone that you may access at any moment. To put it simply, to be at loggerheads is to be in a condition of contentious disagreement. As a result, there is now somewhat of a stalemate in the legal community over precisely what cryptocurrencies are. The judge explains that the Ninth Circuit has not resolved the questions of whether or not courts have the authority to certify classes of investors in this situation, and whether or not certain cryptocurrencies constitute unregistered securities. That pretty about sums it up. But the calm hasn't broken. The judge agreed that the legality of certification in this context is probably untested territory. At a recent judicial conference, she shared her story. This is the jurisdiction over which the Northern California District Court has jurisdiction. Many guests left the Bitcoin securities litigation session at the end of the conference feeling uninformed. The panel's conclusion was met with the same expressions of bewilderment as its onset, as stated in the aforementioned remark. The judge ruled as such. Since this is uncharted legal territory, do you think the judge will rush through the class action lawsuit brought by John Deaton and more than 75,000 XRP holders against a few Zakinov supporters who are saying, yeah, extra peace and security? If I were the judge, I'd be thinking something like, well, the judge effectively is doing this throwing up her hands because she's acknowledging here, even after a panel on crypto, just not the foggiest what's going on here. Unfortunately, this class action lawsuit will be decided by this court. So it's not a slur against the judge as a person. I get that it's tough to have to make a weighty legal choice after being suddenly thrust into the murky realm of crypto. However, it is her responsibility to determine the appropriate course of action. For some reason, I can't help but feel uneasy about it. True, but is she? The air is still calm. But according to Judge Hamilton, the question of whether or not a cryptocurrency is a security is ultimately answered by the motivations of the investor. Yesterday, at a hearing on a motion to certify a class of all XRP holders who purchased, sold, and held the sixth largest cryptocurrency at a loss, Judge Hamilton made some interesting comments. Here then is the claimant's argument. Those who filed the complaints claimed that Ripple Labs conducted an unregistered initial coin offering ICO for XRP. Complainants further claimed that Ripple engaged in misleading practices in order to maximize profits from the XRP price increase, and that the blockchain business had manufactured 100 billion tokens out of thin air during an ongoing initial coin offering that had been going on since 2012. Okay, let's take a break. That's just nonsense, of course. It's been nearly 5 years, and I'm sick of repeating myself. However, Ripple was founded after XRP was developed. It's a hard and fast reality. But, folks, here we are. We're still at peace. The plaintiff filed a motion asking the court to certify a nationwide class of XRP holders who purchased the cryptocurrency from 2017 to the present and suffered damages, as well as a subclass of California residents who fall into this category. Nicholas Spear, of Sussman Godfrey LLP, who represented the plaintiffs and asked the court to certify the class, contended that damages might be determined by deducting losses from the original purchase prices. The attorney stated that it matters that some XRP buyers view cryptocurrency as a security. He further notes that anyone in the class who disagrees with the suit's basis is free to withdraw their participation. That settles it, then? Someone like myself, and I'm not completely bereft of ideas here, but if XRP were to drop, I might be considered for this. If that were the case, however, at least I have an out. However, consider this. You're talking as if it's common knowledge that some XRP holders in 2018 bought at the peak of the biggest price increase for XRP in history. This is true of Bitcoin as well as any other cryptocurrency you care to name. However, there will always be early adopters who pay full price for the best of the best. So, take into account what they bought, and keep in mind that some of them undoubtedly invested a lot of money, and then look at the current price of XRP. Consequently, they're debating the concept of a difference between the two. And then the disparity. Well, I suppose that's what would have to be paid up. It's easy to see how this could become attractive to lawyers. That has the potential to be a multi-million-dollar category. After that, they are allotted a specific percentage. This is fair. Yeah. Well done, indeed. There will always be lawyers who are obviously not acting in good faith and whom I do not regard to be smart. People with the mentality of, oh, we could make money here, also known as ambulance chasers, are present. The good news is that there are ethical lawyers out there like John Deaton. These lawyers are guided by a sense of morality and do what they believe to be right. Now you also have that. I mean, there are going to be good and bad people in every field. Consequently, I find myself wondering what, exactly, we have run into with these lawyers. Simply said, I don't think it looks very well. We're still at peace. Here, in contrast to this view, are the defendants' arguments. Counsel for the defendants, Andrew Z. Michelson of King and Spalding LLP, contended that the suit's lack of specificity makes it unfair to investors who did not buy XRP directly from Ripple. Michelson claims that 3,000 XRP investors who may have been part of the class have submitted affidavits in the SEC's Ripple case stating their disagreement with the lawsuit's premise. Quote, "Not every problem has an out option. When the numbers are that high, that just won't do." This is according to Michelson, an attorney. The defense attorney raised the question of whether the investor bought XRP for international transactions or day trading. As such, we have reached the current stage. I don't claim to know what's going to happen right now, but I don't see how you could proceed with a class action if the judge doesn't grasp the technology and its potential consequences. That being said, it's still possible. I can't make a guess either way. I'm only pointing out that what she stated makes it quite possible that the judge will toss the whole thing because, as is evident, if this class isn't certified, it's the same as tossing this. The plaintiffs could, as far as I'm aware, file an appeal against that ruling. Still, there's no guarantee that anything will materialize from that, either. Just going to have to wait and see what the hell happens here, I guess. But dude, if you don't understand what the technology is and the nature of decentralization, you're not going to necessarily get to the appropriate conclusion when it comes to finding out whether the claims that are being made as to, the declaration that XRP is a security and what the objective is. It can be pure chance that you arrive at the correct conclusion. That's why this situation has me worried. As for me, I don't offer financial advice. Nothing I write or say should be used as a basis for making any financial decisions. Please like and subscribe my channel. See you later, bye.